the Court of Appeal came to a conclusion that release him, drop the charges against him. And the federal government proceeded to the Supreme Court. And since 1963, when we became a republic, Supreme Court is the highest court in the land. Before then, you could further appeal to the Judicial Committee of the Privy Council of the UK. And Supreme Court looked at the appeal and said, fine, even though the federal government recklessly brought Nnamdi Kanu to Nigeria from Kenya, that is a different aspect entirely. That is under a civil purview, fundamental human rights and diplomatic issues. But now there are charges, criminal charges, bordering on terrorism and treasonable felony against Nnamdi Kanu. And the Supreme Court said, proceed with that trial. And that is why the trial started. Like in the case of Kanu, right now, Kanu is still presumed innocent, despite all the allegations against him, until that matter is brought to a conclusion. So it may not be tidy in terms of official communication to label some as criminals, but perhaps in this sphere of the world,
maybe the sphere was consumed by anger and emotion, and he spoke out of order.
He could have made reference directly to the activities, criminal activities, to prevent criminal activities. Because if you look at Section 14, subsection 2 of the Nigerian Constitution 1999 as amended, it says clearly that the security and the welfare of the citizens shall be the primary purpose of government. So under that purview, you are expected to, maintain peace.
Well, I won't put the burden on you. I will invite Mr. Jim himself. He's media friendly. If you call him, he will come.
Yes.
He will answer for himself why he used those words directly. I don't know what was going on, but let's because they are linked. The protest that led Showore to prison, or to prison, the custody of the police, was in Nnamdi Kanu's case, which we're going to come to in just if you give me some few moments. Let's talk about this issue. There's something disturbing and very concerning. And it's not unique to this administration. I think it happened literally every successive administration, but it feels like it's getting worse by the day. The government comes to claim that, people are free to do whatever it is, but as soon as people want to convert for any reason, there's always an intelligence that comes out of possible disruption. Not allowing people to ventilate their thoughts. Are we playing with fire here, or the government has information that we do not have? Is that a fair assessment of the situation? Because why I'm asking this is to the effect that you don't need anybody's permission to protest. The best is maybe notification, maybe because of the uniqueness of the situation. But sometimes it feels like, it looks like you need some kind of permission. And when we've seen pro-government people protesting, there is no issue. There's no security intelligence. As soon as anti-government are protesting, there's intelligence and all sorts. What do you make of it?
It's peculiar to us here, and is the apprehension that gets attached to it, particularly from the side of the government, that feel often threatened. Because like you said, protest is a fundamental human right. What is protest? I'm not satisfied with this. Please, I'm drawing attention to it. But again, going to precedents. Sometimes when such protests are going on, some take advantage to loot, to destroy public property and things like that. So on the side of government, it is needful that you protect such extended expression of the protest. For instance, I doubt if Lagos has fully recovered from the NSAS protests when some buses were burnt, bus stops and terminals and things like that.
People were killed.
Exactly, and people died. So there were casualties on both sides.
Right.
So on the scale of that, it's good for the government to try and manage the situation. But you are also right. You cannot prevent people from ventilating. In fact, making reference to the last protest led by Showore, the Inspector General of Police went to court by delegation to get an injunction against an order against Showore from protesting. But the judge said no, you cannot get this by ex parte approach. put the other party on notice. And interestingly, the adjourned date came after the protest. And when the protest started, the argument was that they were going to restricted areas. So there are several tactics involved. And the general perception is that you have prevented people from protesting because tear gas canisters were, shot and things like that. So there is still this perceived adversarial relationship between government agencies and the citizens, because the ideal situation is that the police should monitor the protest and ensure it is well carried out while preventing destruction and introduction of criminal activities. But and that is why the police will say, oh, we are your friend. But the citizens have not perceived it in that light, and I think that is an aspect we still need to manage. And in public relations, you talk about perception. The perception of the citizens is that the police is not even on the side of the people, but on the side of the government, you see. And there is a need to listen. Ambassador Keshi was responding to the issue in Madagascar, that you need to listen to the silence and the voices of the people. Because if you go to Madagascar, there were genuine concerns from the citizens, but because of the approach of the government, it went haywire. So there is still that need to lay a solid foundation for collaborative relationship, because we are all talking about national development, and there are issues of concern that we give back to equity, to justice in the country. We must all be interested in them. So like you said, the perception is that no, the government does not just want people to protest. Look at the protests against hardship in the land and things like that also. And I doubt if we are going to move away from this operational mindset soon, because if you also study the foundation of the police system in Nigeria, it was designed to protect the interest of those who brought that system and their business. And despite the fact that we have been freed from,
we're independent
for about 65 years, we have not done anything to work on that foundation.
Okay. Let's talk about, without trying to speak to any of the case or the merit of the case, which is still in court, Nnamdi Kanu's case. But make of, just peripherally, let's look at what has been happening in the past few days. First, we woke up to find out that whether he sacked them or whatever happened, it says there's no longer legal representation, and he says he's going to defend himself, pro se. As a pro se litigant in this case. Well, he said he should be given time to study the case file. He got his case file, and then the day he was supposed to open defense, he said, look, I've read the case file, there's no valid charge against me, so dismiss it. What does the law say about this situation? I even know that the judge advised him to seek legal expertise and counsel before he puts down anything in the written address.
Thank you very much. In the criminal justice ecosystem, there are three strong factors. You talk about thorough investigation, you talk about diligent prosecution before a committed judiciary. And how are these playing out now? Let me start from the aspect that has been of concern to quite a number of stakeholders. That, the Court of Appeal came to a conclusion that release him, drop the charges against him. And the federal government proceeded to the Supreme Court. And since 1963, when we became a republic, Supreme Court is the highest court in the land. Before then, you could further appeal to the Judicial Committee of the Privy Council of the UK. And Supreme Court looked at the appeal and said, fine, even though the federal government recklessly brought Nnamdi Kanu to Nigeria from Kenya, that is a different aspect entirely. That is under a civil purview, fundamental human rights and diplomatic issues. But now there are charges, criminal charges, bordering on terrorism and treasonable felony against Nnamdi Kanu. And the Supreme Court said, proceed with that trial. And that is why the trial started again. And now, when you are arraigned and you are confronted with the charges, you have either of two options: to plead guilty, which fast tracks the whole process, or to claim that you are not guilty. So he pleaded not guilty. So he subscribed to prosecution. And to summarize, the prosecution came to their own conclusion after calling 5 witnesses that there is a case to answer here, and when you come to that point, there is also another option. Nnamdi Kanu's legal team now submitted a no case to answer address to the court, which the court did not allow. The court said, no, we cannot allow this because you have a case to answer. Now, you have 6 days from the 23rd of October to open your defense, you see. And that is why, if you notice, I think it was on the 20th that the protest came up and everything. But the judiciary is not subject to protest. You know what I mean? It's a different procedure entirely. So the protest may be perceived as being sensational. So right now, what the court is saying is that defend yourself. And as at that time, he had a team of legal experts, including the former Attorney General of the Federation, Senior Advocate of Nigeria, Agabi. But shockingly, he came to court and sacked all his lawyers, and that he should be given his file, that he was ready to defend himself. And when he collected the file and studied it, he came back to court. In fact, before then, he requested that he was calling some witnesses, top profile, including Wike, Governor Sanwo-Olu, a former Attorney General, Malami, and all of them. And coming back to court again, he changed his mind and said there is no extant law on which to even try him, that what the prosecution has done just wasted efforts, that the judge should release him on bail. And the judge advised him that, Mr. Man, it's not a civil matter. Consult legal experts. And there is no law that says you cannot defend yourself. But this is an intricate matter. And that is why the Honorable Justice has said, okay, we are giving you between 4th and 6th of November to come up. If you still claim that there is no case against you, submit your written address to the court, because we are wrapping up this case. But he must be seen to have been given what is called fair hearing, which the court is trying to do, because the senior silk, Awomolo, was disturbed that this honorable court gave Nnamdi Kanu 6 days. Why going for adjournment again? I think all these are just to at least ensure, and the Honorable Justice said it himself, that even if not to man, he's accountable to God. So where we are now is that there are several dramas, and even some stakeholders, some colleagues have wondered that, hey, what is going on?
Just without trying to cut your train of thoughts, what is the way he's going about it? Are you worried? I think it's just a client so sacking his lawyers as the law allows him. Is he making a mistake?
We cannot claim that he's making a mistake. I think he knows what he's doing, and I will explain that. Even at a point, he said through his counsels that he was sick and that the ailment was life-threatening. He should be released to go to the hospital. But the court constituted a team of medical doctors through the Nigerian Medical Association that submitted a report to the court that he is fit to stand trial. So there had been several, and you recall that at a time, he even confronted Honorable Justice Betanyako in court that she had no ground to try him, and asked her to recuse herself, and the Honorable Justice recused herself. So there was a time he told his lawyer to keep quiet and things like that. I think what is going on can best be explained by me by taking it to marketing. When a product hits the market and succeeds with that entrance, it starts climbing and climbing until it gets to saturation, and that's when you need to bring in a promo. Otherwise, it goes into a plateau and begins to struggle. I think this team of Nnamdi Kanu's advocacy is off. If you have noticed, even the many people following him to court when it all started, those ones are gone now. And in the international environment, Simon Ekpa, who also was charged with similar allegations in Finland, has been convicted to 6 years imprisonment. And many are telling Nigeria that, come, do you have a justice system? So there are several issues involved. And now some are saying, let's have a political resolution. The question some of us are asking from the public relations angle is that the president, even though he's empowered by Section 5 of the Nigerian Constitution 1999 as amended to exercise executive power over the country, he does not control the judiciary, administratively. Though he has the prerogative through the Attorney General of the Federation to say we are withdrawing the charges against Nnamdi Kanu, he should be released. But now, if such is done, will one camp not say she will arrest protests and twisted? So it's a dicey situation. And from what I have realized, I think the government is just saying, let the law have its way. And that's why he's been told, defend yourself. And the opportunity is still open. So if he returns to court now, it's either he's coming to file a written submission that there is no case against him, he's not defending himself, which will now put him at the mercy of the prosecution's case, you see? And or to say he wants to buy time again, he now wants to hire new lawyers as the Honorable Justice advised him to. So it's a dicey situation.
We're going to keep our eyes and our ears close to the case. Because it's one interesting case that has been dragged
absolutely
for many for a long time. But almost thank you so much, Jide Ologun, legal practitioner, for your very intelligent insight into this subject matter. Thank you so much.
Never be tried in any court of law in Nigeria. That's what the law says. Say it again. Anybody standing in trial or coming to try me is a terrorist. That's what their law says. As simple as that. Not me. As simple as that. Section.
Say he wants to buy time again, he now wants to hire new lawyers as the Honorable Justice advised him to. So it's a dicey situation.
We're going to keep our eyes and our ears close to the case. Because it's one interesting case that has been dragged
absolutely
for many for a long time. But almost thank you so much, Jide Ologun, legal practitioner, for your very intelligent insight into this subject matter. Thank you so much.
Never be tried in any court of law in Nigeria. That's what the law says. Say it again. Anybody standing in trial or coming to try me is a terrorist. That's what their law says. As simple as that. Not me. As simple as that. Section 2, subsection 3F of Terrorism Prevention and Prohibition Act. That's what it says. Any cause considered to try me is committing an act of terrorism. Yes. Very clear. You cannot violate a treaty that Nigeria entered into and then come to try that very person is not done anywhere in the world. So you must be aware of that. Yes. So that is why there is all these ridiculous delays. That is what Supreme Court said. I did not jump bail. My home was invaded. They came to kill me and I survived. They came to Kenya to kidnap me, brought me back to this country and seeking to try me, which the law says cannot happen. You cannot violate a treaty that Nigeria entered into and then hope to stand on that illegality to conduct a trial is not done anywhere in the world. I have in my case.